Hello, John. How are you?
I'm good. You?
I'm fine, thank you. And I'm happy to see you. You're a new guest on this show for the Wicked YouTube series. I'm very happy that you're here today because we're going to be talking about a subject that I don't think we ever covered before on the series. And it's actually a rare subject in criminal law. Not a lot of people know about it, not even many experienced lawyers. And it's scary to many of us. It's the DRE cases. And you're the perfect guest to talk to about this subject because you know a lot about these cases and you actually um, do talk about them in conferences and you do a lot of CPDs. So I'm really very happy to have you today as my guest, John. I'll let you, though, first, before we get into this topic, introduce yourself to our viewers and
Sure.
just tell us what you do.
Sure. So I work in Ottawa at a law firm called Bain, Seller, Erdel McRae. We do exclusively criminal law. I've been practicing for 10 years now. In addition to working here, I also teach at the University of Ottawa Law School and Algonquin College. My practice is um, across the board, but I have a couple areas that I do more work in than others, and DRE, impaired by drugs, is one of those areas. I've focused my practice in that area slightly. I argued a very narrow, specific issue a number of years ago in a number of cases on rolling logs, and that sort of started my interest in this area. In addition to that, I also do a number of national security files and Section 38 amicus work is what a lot of my practice is now. But at the end of the day, DREs has always been one of my interests, and I continue to both talk about them and practice these types of cases.
So let's talk about these types of cases. Not a lot of people know about them, and they can be scary
Yep.
because they're very different and even different from the regular alcohol related charges. So let's then talk about what is a DRE? Let's start with that.
So a DRE, so actually the term refers to two things. So DREs can be drug recognition experts or drug recognition evaluators. So those are the police officers that have been specially trained by this organization in the United States called the International Associations of Chief of Police. They are the only body capable of designating police officers as DREs. So DREs undertake and complete the drug recognition evaluation of a person. And so the DRE expert performs the DRE evaluation on a subject. And that's how we determine whether someone's been impaired by drugs. So unlike alcohol, where we have the ASD at the roadside, pass fail, and then we have the breathalyzer at the station where we get a very accurate scientific reading of the alcohol in the blood and in the breath. We don't have that for drugs. There's no scientific
Mhm.
equipment. Number of reasons for that. One, there are more than one drug type and they all impact you differently. If you consume cocaine and marijuana, those are going to have very two different reactions to your body and they're going to demonstrate in different ways. So there's no easy one scientific test to determine drug consumption. So instead, at the roadside, what we rely upon are the standardized field sobriety test, SFST, which had
Yeah,
existed for a long time, and we those can be used in the alcohol consumption
right.
scenario. But in the drug, that's sort of the only on-scene test that can be done. So if the officer has suspicion of drug consumption, but not reasonable probable grounds, the FST could raise that suspicion to RPG.
And what are they? If you can just give us a
Yeah,
bit.
there's the SFST has three main components. They look at your eyes. Again, they're looking for what's called horizontal gaze nystagmus or vertical gaze nystagmus, and these are essentially whether your eyes are vibrating either vertically or horizontally, sort of uncontrollably. And this is often a side effect of certain drugs. So people who consume cocaine, for example, often there's a bit of a vibration in your eyes, which can be detected. Then they have you do the one leg stand. So that's where they ask you to choose one of your two legs, stand on that leg and lift your other leg, and to hold that pose for 30 seconds, trying to remain balanced and counting 30 seconds in your head. And then they determine if you sway more than 2 inches in any direction, whether you can keep your foot up, whether you can remain balanced. The and the third test is the walk and turn test. So that's where they have you walk 9 steps in a straight line, heel to toe, do a very deliberate turn, and walk back again, heel to toe. Um, all these two tests are called divided attention tests. And so that means that there's a physical component, the standing on one leg or the walking, and a mental component, counting to 30, counting your steps. And this is meant to emulate driving, because driving has a physical component, steering wheel, gas, stick shift, whatever it is, and a mental, watching the people around you and so forth. And so these tests are designed to determine whether you have an issue with doing two activities at once at the same time, which would then suggest your ability to drive would be impaired as well. So that's the field sobriety test. When you get to the station and you're undertaking the DRE evaluation, it's a much larger evaluation. We have the eye assessment, the one leg stand, and the walk and turn test are all repeated. The one leg test, you actually do it on both legs in the DRE evaluation. In the SFST, you only do one, but you do both. And then there's also one more physical test where they have you touch your nose with your pointer finger of both hands with your eyes closed. And there's sort of two parts to this test. One, you must use the tip of your finger, which is the end, not the pad. So a lot of people, if I told you touch your nose, a lot of people are going to do this. And so a sober person would fail. That's a fail. That's a pass. It seems minor, but that is how much they're looking for it. So that's one thing they're looking for is, with your eyes closed, can you touch your nose, okay, with the right part of your finger? And they basically have you hold both fingers out, and they'll tell you, okay, left finger, left finger. And so can you pay attention and do that? And then on top of those physical testings, they do a number of medical measurements, your blood pressure, your heart rate, your temperature. They'll look in your nasal cavity and your throat. Do they see signs of drug consumptions? They'll look on your arms for injection marks. And they'll also ask you a series of questions, which we can get to later. But the DRE evaluation usually takes about 45 minutes to an hour. The SFST is usually 5-10 minutes. It's much shorter and much more compact.
And the SFSTs are the ones, they would be in the drinking cases, the equivalent of the ASD. So that's what they do on the roadside.
Yeah.
But of course here, I mean, they do it on the roadside. So depending on where you're being stopped, I mean, if you're stopped in an area that's uncomfortable and they're asked you to walk, I mean, there are so many factors that come into play.
And so one issue that I've seen a few times is where the officer deems the location you're at unsafe to do the SFST. And so then they transport you in the back of the police car, often under arrest and handcuffs, to a parking lot or whatever. And so in those cases, you might have a charter argument saying, okay, like my client's been arrested, handcuffed, he's obviously detained.
Yeah.
And does that raise charter issues at that point? I mean, it's called the field sobriety test because it's meant to be done in the field. But of course, they have to pay attention. Is it raining? Is the road wet?
Is it cold, minus 60?
What's the shoe they're wearing? And in the training materials for DREs, they're told that, there's a percentage of the population that even sober can't do these tests. Some people have poor balance, right? Age, back issues.
Or some people
issues.
will do better, a dancer or, have better balance. Yeah.
And it's important that, keep in mind that DREs are considered experts by the court, right? They are required to comply with MOHAN and expert responsibilities. And so in your cross-examination of them, I always ask them, okay, so, how did you consider the possibility that maybe my client was sober? How did you determine that there was no false positive, so this wasn't caused by poor balance and not drug impairment? And often they can't provide a good answer there, but it's important that we remember, and I often take judges to these stats, right? The stat here for the walk and turn test, I think it's like 20% of people who are sober are gonna fail, and that's a significant value. And you want to remind the judge that these aren't tests that every sober person's going to pass every time, and so these are factors you have to consider.
Well, and so while we're talking about these tests, so how reliable are they? And if they aren't that reliable, and I understand that in the context of drugs, we don't have like alcohol machines that can accurately measure the level of impairment. But I mean, why do we rely on them if there are reliability issues?
So I think the starting point is, there definitely are reliability issues because we don't have a scientific method to test for presence of drugs in the body. Mm-hmm. Unlike alcohol, if you go to the station, your client blows, they blow 100, unless you're getting that reading kick, they're likely going to be convicted, right? That's a very scientifically accurate measurement. In impaired by drug, we don't have that. So what we have instead is we have these DREs, human beings who have been trained to perform very specific tasks, make observations, and then come to a conclusion based on those observations. And so it's that conclusion by this human being that ultimately serves as the determination of impairment. But like any other human being, they can make mistakes. And so there's inherently reliability concerns anytime you're relying on an opinion of a human. And again, these DREs, and while they're considered experts by the courts and the legislation, they're police officers. They've been trained. You must be a police officer to become a DRE. That certification is only given out by this one organization in the United States. And so you're not, while there are some defense DRE experts out there you can consult, they're all ex-police officers. Bias is always something you want to turn your mind to, and these officers need to be able to testify as experts and not show some level of bias, right? So all the concerns you'd have with an expert witness apply to DREs, but more so specifically because that opinion they have really is the main crux of the Crown's case. But it's important to remember that, an impaired by alcohol, if that breath reading goes in, it is what it is. We all know what it is. You're elected to be convicted. But in a DRE case, it's not the same. There might be charter issues. You might have areas you can cross-examine the DRE expert on. But at the end of the day, if their opinion goes in, a judge is not going to automatically convict because what they're telling the judge is what they observed, which the judge can accept or not accept.
Yeah.
And they provide their expert opinion. But like any other expert opinion, the judge may accept part of it, none of it, all of it. But a judge can't say, I'm convicting you because this DRE concluded you were impaired. The judge has to be satisfied beyond a reasonable doubt. And so what the DRE officers need to do, and in my experience often struggle to do, is explain to the judge how these observations that they observed lead to the conclusions they drew. What steps are they going through? What analysis are they undertaking? And then, I like to ask DREs hypotheticals. What would have happened if my client had done perfectly in the walk and turn test, but everything else was the same? Would your opinion have changed? Again, as an expert witness, they need to be able to answer hypotheticals. And often I get them looking at me like deer in the headlights, like, well, I don't know, or it wouldn't change anything. Okay, what if these two factors were changed? Would that change your opinion? And so many times they're really reluctant to change their opinion. And then how could you rely on that, where it doesn't really matter what you change, their opinion remains the same? So a lot of the skills that you would use on cross-examining experts come into play. And it's important that you remind the judge, this is an expert. You have to, assess his evidence in that light. And you don't just adopt his conclusion. You need to satisfy yourself that you as a judge, having heard the observations and the analysis, do you conclude with the result? Or are you left with a doubt? And so unlike impaired by alcohol, where often, resolutions might be tempting, especially where it's an overwhelming case, in impaired by drug, you're not getting stream A or stream B. There's no advanced license return. So you're waiting that 1 year no driving. Post-conviction, you're getting the same sentence. The fine, driving prohibition. And so there really isn't much disadvantage to going to trial. And in these cases, even if you lose all your charters and the expert's opinion's in, it doesn't mean you're being convicted. And so I strongly urge anyone with a DRE case to take it to trial unless there's very good mitigating reasons why your client doesn't want to, maybe an offer of a careless, or there are some other mitigating factors. But on a straight impaired by drug, single count information, I think they should all be going to trial in the vast majority of cases.
And aren't you allowed, Jon, to request the history of that DRE to see on how many cases that DRE was able to accurately predict impairment?
Yes. So these are called the rolling logs. And
Right.
so this is part of the regulation. DREs are required to keep a rolling log, which is just a log of all their evaluations. And it's rolling because it continues growing as they do more. This was the issue that was hotly contested maybe 5 or 6 years ago now. And I had a number of cases in Ottawa.
I had one and we were working together on that one. So
yeah, and essentially the Crown's position was they weren't relevant. We were arguing that it was. It went to the Court of Appeal, and the Court of Appeal agreed with us. They are relevant. So now we get them. And now that we've seen them...
So how do we use them?
Well, I don't think they have that much use in the vast majority of cases, which, which should be the case. The log should demonstrate that the expert is doing their job, and you'd expect to see that the vast majority of the time, the drug classification that they called is found in the urine. And that's really what it comes down to. But I'll step aside for a second. But it's important to remember that if someone is deemed by DRE to have be impaired, there's a urine or a blood demand made. Blood is quite rare because you need a nurse to administer that, and police forces don't typically have nurses. So we almost always see urine. Urine sent off to CFS, we get analysis back. That does not confirm impairment because drugs exist in the body for days, weeks, months after consumption. So the urinalysis simply demonstrates past consumption, but does not speak to impairment. And you can legally smoke marijuana on a weekend, drive 2 weeks later, and it might still be in your system, but you're not impaired.
Yeah.
So it's important to understand that the urine is not a confirmation of the expert's determination, but the rolling logs, the way they're set up, is essentially that. The log is the date, the name of the person, the expert's opinion, and then whether the tox results confirm that or not. And so one way you could use them is, of course, if this expert frequently has calls where they say drug A and that drug's not in the urine. You might want to ask them about that. Like, does this concern you as an expert? Have you gotten for retraining? Like, what have you done about this? I don't think you're going to get a judge to say this person's not an expert as a result, but again, it might call into question their assessment. The other thing to keep in mind is the regulation that prescribes the DRE evaluation is a single page regulation of the criminal code, which sets out the test just by name, doesn't define them, doesn't explain them. And so, Crown defense, if you want to understand these tests, you need to get a copy of the training manuals. And so I've never had a Crown voluntarily disclose this, but in every case, I would urge you to request the DRE training manual that your DRE was trained on, because every year or two, they have a new one. I can't tell you how many times I've been disclosed one manual and I go to cross-examine the DRE and he's like, this is not the manual I used. I got to break and get the right one. And, they're similar enough, but I always request the one he was trained on. And it's important to know that there's actually 3 manuals. In order to do the DRE, you need to have already completed the SFST training and be a trained SFST administrator. So some people, they might get their SFST training a year earlier and then they just rely on that. Other people, they get sent to an SFST course and then the next week they're doing the DRE. But because some of the physical testing are described in the SFST manual, they're not repeated in the DRE manual. So the only way to get the testing instructions for the walk and turn and the one leg stand is in the SFST manual. Mm-hmm. So I always request the SFST manual that this DRE was trained on, the DRE training manual, and there's a third one called, I think it's called the pre-DRE school book. So they're supposed to have read it before they come to the classroom. So usually request all 3. These manuals, unfortunately, are not what you typically think of as a manual where everything's set out with checklists and steps. There are copies of PowerPoint slides that are shown in these classes, and there's spaces for students or training officers to take notes. And it's pretty clear that there's a lot of information that's shared orally in the classes and not in the manual, and we don't get that. But nonetheless, there's still valuable information in the manual. And you can't do these cross-examinations well without knowing that manual. You need to have read it, understood it, because how can you challenge what the DRE did, whether it was accurate or not, whether it was appropriate or not, unless you have the manual? I'll give you an example. During the physical testing, the officer has to explain what they want the subject to do. And throughout the instructions, they'll ask, do you understand? A number of times. And obviously the subject is expected to say yes. And the reason for this is because if someone does poorly on, let's say, the walk and turn test, they do really badly. If the DRE doesn't know whether they understood the instructions or not, well, the results are meaningless because it could have been they understood the instructions correctly, but they're impaired and so couldn't do it. But it could also be that they didn't understand it or they thought they did, and what they did was in line with what they thought the instructions were, but they simply misunderstood.
Yeah. And
so in order for those results to have any value, the DRE evaluator needs to be satisfied that the subject understood the instructions, okay? So again, if they don't go through that instruction phase and ask those questions, if you have a video of the evaluation, well, that's something you want to cross-examine on, right? Like the manual says you have to do it. There's a reason for it. It's a very important reason. And if they didn't do that, well, that's a good area to cross, but you wouldn't know that unless you've read the manual and you know how the tests are supposed to be performed. Which brings me to another issue, which I conduct now. So this is voluntariness, which is another issue that frequently comes up. So during these evaluations, the DRE will ask questions of the subject. Sometimes they're on the form that gets completed, so they ask them every time. Other times they're making small talk, whatever it is. One of the questions they always ask is, when did you last consume drugs? What was it? Okay. And
Like alcohol, it's the same question
yeah,
as well.
exactly.
Yeah.
But if someone says, I smoked a joint half an hour ago,
Yeah.
well, how much you want to bet that expert's going to opine that your client's impaired by marijuana?
Yeah.
And so the reason that voluntariness is automatically triggered is because this is an expert witness giving an opinion based on the evaluation during which your client made statements to a person of authority. Automatically triggers voluntariness. And there's a summary conviction appeal case in Ontario which essentially send the trial back because the judge failed to consider voluntariness. So it's a requirement. And so you obviously want to fight it. In some jurisdictions, the police forces do not record the evaluation. The code says you may, so it's optional. Some forces chose not to, and I've heard a number of
Well,
reasons.
wait a minute. What about body-worn cameras? Because I was going to ask you about that. Like some police forces now have these cameras on. So what about that though?
So if they have those, so I've not seen a jurisdiction not record the evaluation but have body cam, so I'm not sure. But presumably the body cam, if it existed, would show part of the evaluation. But any jurisdiction where they're intentionally not filming the evaluation, they're gonna the Crown's gonna have a hard time proving voluntariness on the Moore McFarlane issue, where the case law says where you have the ability to record it, you know that they're going to make a statement, and you choose not to. Well, that makes it harder for the Crown to have it deemed admissible. That issue is sort of less prevalent. More and more police forces are now recording them or have body cams. And those are very useful because you can actually now watch the evaluation. Did the officer perform it correctly? Did they go through the steps? How did your client actually do? And so forth. And sometimes you might see things that the evaluator noted incorrectly. You also might see comments that your client's making that weren't recorded, whatever it is. So obviously, it helpful in that degree. But also it could be quite harmful. The judge might watch this and say, well, your client's clearly impaired. Like he can't stand still. He can't walk straight. That's, I guess, a downside. But the voluntariness, so it's not just whether it's recorded or not, the accuracy of the statement. But there's another argument that I've made a number of times, and it's that essentially the regulation prescribes the testing that must be completed as part of the DRE evaluation. Mm-hmm. Asking questions is not set out in there, and that's because you have a right to silence. You can't be forced to answer questions. But you're brought into this room. You're spoken to a lawyer. The lawyer says you have to do the testing. You get in there, and the evaluator says, I'm going to do a bunch of tests with you. They do not tell you you have to do all of these things, but you don't have to answer questions, right? And the questions are sprinkled throughout, at the beginning, at the end. And if you don't know that that's not a requirement, you're probably going to think you have to answer them. And so you're going to answer these questions honestly. But that might amount to police trickery, not on an individual police level, but these forms that they're trained on, that they're told to use in every occasion, has the spots for these questions and answers, even though there's a constitutional right to silence and it's not part of the regulation. And that, and again, it's, and then how often does the DRE expert, when they ask the question, when did you last consume drugs? What was it? Their opinion almost always matches that. And my cross-examination, I'll ask the DRE, you agree with me that you didn't have to ask these questions? No. And my client could have ignored them, right? And you would have believed nothing about it. Okay, so let's imagine that you didn't have my client's answers. How would your opinion change? And every time it wouldn't change at all. It'd be the exact same. Okay, then why did you ask the questions? Yeah. Why did you ask questions that you have no right to ask and they don't have to answer? Why would you do it if you don't need them? Stare at me. Well, because I can't. I've never heard a good answer, right? So that's a problem as well. There's some form of police trickery, so I would urge you to always argue the voluntariness. You might lose it, but it's something you might win if you're successful on the voluntariness. And your client's statements can't be admitted, the next question is, well, what do you do with that? And I think there's two things that matter there. One, depending on your DRE and how capable they are answering questions, you might be able to argue that this is an expert witness. They've made their opinion based on the evaluation they completed, including the statements by your client. And it's virtually impossible in a vacuum to say, okay, do not consider the statements made, but tell me what your opinion would be without that. Because they're always going to say the same thing because of course they are. So, is that really a fair request to make of this expert? Is that something they can genuinely actually do? Or are they just giving the answer that they want you to hear? Again, so maybe you can argue the judge that this person, in light of that, the weight of their expert opinion should be given very little weight because of the fact that they can't engage in this hypothetical. The other consideration that I think is important, I think is often lost, is if you got a judge to deem that it's not voluntary, those "do you understand" questions, the answer of yes, become that much more important. Because if you did your job correctly in the voir dire on the voluntariness, they'll have agreed with you that the reason they ask those questions is because the answer of yes is critical to being able to assess the results of that evaluation. So if the answer yes is deemed not voluntary, then that officer has watched your client do something, but doesn't know whether they understood or not, at least admissible evidence they knew they understood or not.
Yeah.
So how could their opinion be worth any weight if they don't know whether the subject understood or simply did what they thought they did? And so again, I think if you have a good judge, you can explain this well, you have an argument that the expert's opinion should be given no weight, because in light of the lack of voluntariness, it significantly undercuts the ability of to give weight.
And really, in these cases, it really comes down to the expert's opinion. You don't have a machine result that is on paper.
This one DRE's opinion is all of the Crown's case. And so you want to challenge in all these ways. Did they do it correctly? And again, it's important to remember, the test has value because it's been standardized. It's been standardized, it's been tested, it's been confirmed, but only if you do it in a standardized method. And so if you can, in your client's evaluation, if you can demonstrate that the officer failed to do one of the tests properly or something like that, you might be able to convince the judge, well, this wasn't done according to the standard method, so therefore it wasn't done in accordance with the regulation, therefore it's an illegal evaluation, it's unlawful, it's a charter breach, can't rely on it. So, small mistakes could have this ripple effect. And going back to the voluntariness and the importance of these questions being asked, if you think about the regulation, again, it doesn't permit questions to be asked. It just has the physical tests and the medical tests. But the DRE's expertise is limited to the regulation. And the Supreme Court in Bingley set this out. They're automatically experts, defined by the code, experts on administering the regulation. And so as an expert, they should not be considering anything your client said, because that's not within the regulation. And so that's outside the gambit of their expertise. And so you have a DRE expert coming and saying, well, of course I considered what he said. When he last ate food, when he last consumed drugs, of course I considered that as part of my expertise. Well, you might have an argument then that he's exceeded the parameters of his designated expertise because that's not part of the regulation. And then you might have an argument again, you can't give his experts any weight because he exceeded his expertise in giving that opinion. So it's, it might seem like, well, it's video recorded, my client spoke to a lawyer, he knew what he was doing, it's voluntary. Voluntariness in this scenario is very different, and it's critical that you fight it because you never know what's going to happen, and it could have significant value to your client if you can have the statements deemed not voluntary.
And so to clarify, Jon, because you did mention the charter issues, but for lawyers in these particular cases, so if you have a call from a client who says that he's being arrested for impaired driving by alcohol, so what specific advice in these cases are you required to give to your client?
So the advice I give on impaired by drug versus alcohol, the main difference is I explain to them you're going to be not blowing a machine, you're going to be doing a physical test. It's going to be very different. One caveat, the DRE can require your client to provide a breath sample if there's suspicion or concern that alcohol could be the cause. They need to have suspicion. So they can't just do it to say, well, let's just get it out of the way and make sure it's not alcohol. So I tell I tell someone called to the station, you might have to blow. If so, blow. It's going to be twice. I don't want you to answer any questions, but you may have to provide a sample. You may not. You may go straight to this physical evaluation. I do my best to explain what the physical evaluations are generally so they have an idea, explain what they're looking for. They're looking for balance mainly. Can you count in your head? Things like that. And I do my best to explain, I want you to answer no questions. I know it's going to be hard. They're going to ask them. Just tell them, I'm not answering any questions. I've yet to have a client actually listen to me not answer questions during the DRE evaluation.
Well, especially if they're impaired, right? Like it's even...
Well, that's it. But I keep hoping that someone will listen to me, and then maybe the officer will fight with them and get into a bit of an argument saying they have to answer, and that would be a really interesting charter breach, right? Yeah. But because I'm not convinced that most DRE officers realize, A, that the question and answer is not part of the regulated evaluation, or two, that if someone refused, I wouldn't be shocked if an officer charged someone with refusal for refusing to answer the questions in evaluation, not that would obviously be an illegal charge and you'd be able to defend it. But because my experience of DRE's understanding of the actual regulation and what they're legally allowed to do is very limited, because they get their training in the US on the American method, and they come back to Canada and there's slight variations. And if you never read the regulation and not really concern yourself with the differences, you might just continue to perform what you were taught in the States, and that might be problematic. Well, good for the defense, problematic for the police who are not performing a lawful evaluation.
So, but one last point that do want to address, Jon, is, well, what about the cases where there's a mix of both alcohol and drugs? So then how can I mean, ultimately he's going to be impaired, but I mean, like, if
Yeah.
we want to determine, like, what is it that had more of an impact here?
So, I mean, at the end of the day, you typically would be charged with one count of impaired by drug or alcohol. And
Mhm.
so, for impaired by drug, the judge does not need to find beyond a reasonable doubt what drug you were impaired by. The judge should be satisfied that you were impaired by a drug to any degree, right? And, unlike alcohol, you go to the bar, you can have one beer, you can drive home, you're not impaired. You're not even close, right?
Yeah.
It's not the same as drugs. Like, one puff on a joint might get you impaired, right?
Yeah.
Drugs affect people differently, and there's no real building up to it, so to speak. And so on impaired by drug, we don't have the readings, but if the judge is satisfied that you were impaired to any degree by even prescription drug, we see this occasionally where someone gets prescription medication, they're not told by the doctor that don't mix with alcohol, or they don't read it, or they don't pay attention, and then they go to the bar, they have one drink, driving home, and they're impaired because the combination of the drugs and the alcohol, right? So it doesn't have to be an illicit drug. The judge has to be satisfied that you consumed a drug, legal or not, and that it caused an impairment. And so it's really important in these cases, more than impaired by alcohol, where, let's say impaired by alcohol, you have a charter, you kick the breath reading, so you just have the signs of impairment at the road, so bad driving, odor of alcohol, that might not be enough to get a conviction for impairment. Impaired by drug, if you kick the evaluation, you're still on the bad driving, but you likely have the SFST, which includes some of these testing. And a judge might find the fact that the subject did poorly on the walk and turn and the one leg test on the SFST is sufficient enough for me to conclude that he was impaired, combined with the bad driving, whatever it is.
Mm-hmm.
So it's kicking the DRE evaluation may not be enough, because you don't need much evidence to find impairment to any degree. But this is another point to keep in mind, is that police officers at the roadside or anywhere else pulling someone over, they all know the signs of impaired by alcohol. We all do. We see it all the time.
Yeah.
Slurred speech, memory issues, glossy eyes, stumbling, whatever it is, smelling like alcohol. Every human knows what that looks like. We've all seen a drunk person. Mm-hmm. The same is not true for drugs.
Yeah.
I mean, how many people have seen someone high on cocaine and marijuana and meth and fentanyl, right? They react differently. And so when an officer says in their notes, I observed glossy eyes and slurred speech, therefore I was concerned for impaired by drug. But question them on that. What about slurred speech led you to conclude that it was impaired by a drug? What drugs caused that? Have you training on this? Yeah. And officers sort of stare at you because there isn't. And you tell the judge, Your Honor, you take judicial notice, essentially, of impaired by alcohol symptoms. That's essentially what's happening in the court. Everyone knows them. But you can't do that for impaired by drugs. They're all different drugs. They affect you differently. They present differently. So just because an officer saw someone stumbling and slurring their speech and then blew 0 on the ASD, that might not be enough for a conviction impaired by drug. And it wouldn't be, because what's your knowledge base to draw that those are caused by impaired by drug? And something else to always keep in mind is, in my experience, often these cases end up because someone's passed out the steering wheel at a green light or in the middle of the road. This happens quite frequently. And then that usually leads to the officers to conclude, well, this must be impaired by drug. They passed out, right? But you can be impaired by alcohol, drugs, or a medical impairment, right? Mm-hmm. You could have a stroke, you could have a heart attack, you could have any other medical issues. And so I always ask these experts, what did you do to determine that impaired by medical was not the cause? Because you're not a doctor. And the vast majority of them say, well, I asked the subject, do you have any medical concerns? Okay, that might be okay if they're diabetic or if they're in cancer treatment, but if someone had a stroke or heart attack, they may not know. Yeah. And so, when you get a stroke while driving, you might have slurred speech afterwards. You might be having one side might be slightly paralyzed. You might be stumbling a lot. You might not be able to balance after a stroke, right? So a lot of symptoms that might appear by drug might have medical answer. And the experts, the DRE experts, supposed to be unbiased, didn't turn their mind to that or can't negate that possibility. Well, in your final submission to the judge, Your Honor, you can't be convinced beyond reasonable doubt that it's drugs because there's potential for medical. Same with a car crash, right? The person, is it a head injury from the crash or is it a drug impairment? So even though the DREs never really turn their mind to it, it's important that we don't forget it and question them. And what did they do? And if they did nothing, well, that might be enough.
All right. Well, Jon, I think here we covered quite a lot about the DRE area, and that was really very interesting. I mean, I know I still remember the case that we worked on together when we had this, when the rolling logs was an issue back in the days. But it's really very interesting here. And again, for people who, because I know that there are some people who have these cases and they don't really know what to do about them. And honestly, Jon Doody is really almost like an expert in this area. So how can people find you? Where can they find you?
If I have our website online, BSP Criminal Law is our website. Feel free to reach out. I'll do my best to answer questions on DREs. I presented on DREs before, number of years ago at the County of Carleton Law Association Montebello conference, and that was video recorded, and the video is attainable. And if you want to watch me rant for 45 minutes about DREs, that video exists. And I also presented last month, December 2024, at the Law Society CBD on impaired driving on a panel on DRE as well. So those are both resources that are likely available.
And so we will post a link to your firm's website. This way there you will find your contact information. And I honestly strongly recommend anyone who has a DRE case to get in touch with Jon, because he knows a lot and he's very nice. He's very generous with his time. So do not hesitate to contact him. Thank you so much, Jon, for taking the time today to chat with me about that. And hopefully maybe we'll have you back again, either to talk more about DREs or about something else. So thank you so much.
Sounds good. My pleasure. Talk to you later.